Thank you for choosing American Pest CEUs. Hi, I'm Sean Reeves. I'm an Associate Certified Entomologist with American Pest CEUs. I've been in the pest management industry since 1999, and I'll be your instructor for today's course. Today's course was compiled by Jack Launius, who served in the pest management industry for over 30 years. Chapter 2, Regulations to Abide By, Federal Pesticide Laws and Regulations. After studying this chapter, you should be able to explain how and why pesticides are regulated in the United States, discuss the importance of knowing and following federal laws and regulations related to pesticide use, state why certain pesticides are classified as restricted use, distinguish between restricted use and general use pesticide classifications, explain the importance of maintaining accurate records of pesticide applications and employee training. The need for regulation. Pesticides are hazardous substances that can cause serious harm if used improperly. However, they also provide important socioeconomic benefits when used correctly. Pesticides are regulated to utilize their benefits while protecting public health and welfare and preventing harm to the environment. So as you can imagine, there's a major need for regulation. When you think about something like pesticides, think about if they're not handled correctly, how much damage they could do. So this is why there is a lot of regulation for pesticides and why it's very important for you to understand the laws related to them. Further, when we think about the need for regulation, we need to talk about federal and state pesticide laws and regulations control the labeling, sale, and distribution, storage, transportation, use, and disposal of pesticides in the best public interest. Except for human and veterinary drugs, few other chemicals sold in the United States are required to undergo such extensive regulatory review and testing before being registered and marketed. This course addresses the requirements of federal laws and regulations only. States, tribes, territories, and some local jurisdictions may have their own legal requirements concerning pesticides that may be more restrictive than federal law. You are responsible for learning about and complying with all such regulations before making any pesticide application. Ignorance of the law is never an excuse for non-compliance of violations. As we stated here, you need to be aware that these are going to be the federal laws based on the National Core Pesticide Manual. But again, local laws, state laws, tribes, territories, things like that can be different. Make sure you're always keeping up to date with your local laws. Just because something's a federal law, which is going to be the minimum, doesn't mean there's not laws that are even going to go further than the federal laws in your local area. And if you don't keep up with those, you may be making an application outside of the law. Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA. The Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA, is the federal law or statute that regulates the production, transportation, sale, use, and disposal of pesticides. FIFRA is administered by the U.S. Environmental Protection Agency, the EPA. Congress originally enacted FIFRA, amended it considerably in 1972, then again in 1975, 1978, and 1988. FIFRA provides the overall framework for the federal pesticide regulatory program. Under FIFRA, EPA is responsible for registering or authorizing pesticide products for sale, distribution, and use in the United States. Pesticide registration decisions are based on a detailed assessment of the potential effects of a product on human health and the environment when used according to its labeling directions. The EPA-approved labeling has the force of law, so we need to understand who is responsible for registering or authorizing pesticide products for sale, distribution, and use in the United States. That would be the EPA under FIFRA. This is very important because any of you taking exams are probably going to see a question like that on the exam. Although it is a violation of federal law to use any pesticide registered by the EPA in a manner inconsistent with its labeling, FIFRA Section 2 EE excludes several use situations and application procedures. Unless specifically prohibited by the labeling, FIFRA allows a pesticide to be applied to control a target pest not specified on the label if the pesticide is applied to a crop, animal, or site specifically listed on the labeling, e.g., interior of a home, food handling establishments, exterior ornamental plants, corn, and tomatoes. Any method of application. FIFRA also allows a pesticide to be applied at a dosage, concentration, or frequency less than that specified on the labeling, except in the case of termiticides labeled for pre-construction treatments. They also allow a pesticide fertilizer mixture. Realize that if you exercise any of the Section 2 EE exclusions under FIFRA, you alone are responsible for any consequences resulting from such an application. Something important to note here is the fact that you do have liability as a pesticide applicator, not just when we talk about Section 2 EE exclusions under FIFRA, but in reality, anytime you use a pesticide, you are going to have some liability. Now, when it comes to state laws, it can be a little bit different in each state, but you have to understand you have liability. You have to think about each time you make an application, what you're using it for, why you're using it, and make sure you read the label and understand. Because anytime you make a misapplication, you can be held responsible for any consequences resulting from a bad application. So again, with FIFRA Section 2 EE, we can apply a pesticide at a dosage, concentration, or frequency less than that specified on the labeling, but keep in mind, you cannot do this when you're using termiticides labeled for pre-construction treatments. That's an important thing to note. It would never make any sense to put a termiticide out at a less than labeled rate when doing a pre-construction treatment. The whole idea is to prevent termites from getting in that structure. Now, once again, I don't think most of the time you're going to be doing this anyways. I usually just follow the label because it is a federal law, but we do need to understand that there are exemptions on this, and especially those of you taking exams, understand FIFRA Section 2 EE and how it works. FIFRA also gives EPA authority to impose civil or criminal penalties on any person who misuses a pesticide or commits any of the other unlawful acts listed in FIFRA Section 12, stop the sale or use of any pesticide, issue removal orders and seize products to keep them out of the market if it determines the products pose an unreasonable risk, reevaluate older pesticides to ensure that they meet more recent safety standards, implement programs to require the certification of applicators of restricted use pesticides RUPs, protect agricultural workers and pesticide handlers from occupational pesticide exposure. So once again, FIFRA is over the EPA, but is also giving them authority to do these things. When we talk about imposing civil and or criminal penalties on a person who misuses a pesticide, that's you. If you're out there putting out pesticides and you misuse a pesticide, they can come after you. It's not going to be just your employer, it's going to be you. Now, can a company be liable as well? Are they supposed to provide training? Absolutely, but just keep in mind, when you're the one mixing the pesticide, when you're the one using it, you do have liability. Also, FIFRA has given the EPA authority to reevaluate older pesticides to ensure that they meet more recent safety standards. So basically, FIFRA is allowing the EPA to reevaluate pesticides as they go to ensure they are safe by today's standards. All pesticides are classified according to their potential hazards under the circumstances in which they are to be used. Two main classifications are restricted use and unclassified use. Unclassified use pesticides are commonly referred to as general use pesticides. It should be noted, however, that EPA has officially classified very few pesticides as general use. Most pesticides that might be expected to fit into the general use category currently remain unclassified. Normally, General use pesticides have a lower toxicity than RUPs and are so less likely to harm humans or the environment. The general public can buy general use pesticides without special permits or restrictions. Do not forget this section. Any of you taking a core exam in any state are going to get questions pertaining to this. I'm a certified operator in 11 states right now, and I can tell you, almost every exam that I've taken talks about restricted and unclassified use pesticides. Now, most of them are going to refer to them as restricted and general use, but just keep in mind when we talk about restricted use pesticides, that means there is going to be some type of licensing tied to it. So there is going to be some type of state licensing or certification tied to it. And as we talk about here, general use pesticides, those are fine. Those are ones you don't have to worry about. You can go buy those at Home Depot or Lowe's. But we have to understand that most all pesticides are classified as restricted use, but there are a few products that we can go pick up at the local hardware store that are going to be more general use pesticides that have a very low toxicity compared to the RUPs. Generally, EPA classifies a pesticide as restricted use if it exceeds one or more human health toxicity criteria or based on other regulatory standards. EPA may also classify a pesticide as restricted use if it meets certain criteria for hazards to non-target organisms or ecosystems. Still another reason for the restricted use classification is a determination by EPA that a product or class of products may cause unreasonable harm to human health and or the environment without such restriction. The restricted use classification designation may be prominently placed on top of the front panel of the pesticide product labeling. Some pesticide active ingredients may be listed in both use categories depending on the formulation, the application method, and the intended uses. For example, an emulsifiable concentrate formulation of a certain insecticide used on fruit trees might be classified as restricted use if it contains a high percentage of active ingredient, e.g. 70%. However, the same chemical with a low percentage of active ingredient, e.g. 5%, in a granular formulation used to treat turf insects might be regarded as a general use pesticide. The EPA may classify a pesticide as restricted use due to its active ingredients or percentage of the active ingredient. Understand, it's not just the active ingredient that can get it the restricted use classification, it can also be the percentage of the active ingredient. This means if it has a higher percentage of the active ingredient, even though if it typically wouldn't be a restricted use pesticide, because that percentage is higher, as we just talked about, it can be classified as a restricted use pesticide. So that just gives you a little further understanding about how the EPA classifies these products. RUPs may be sold only to certified applicators or their authorized representatives. A certified applicator is an individual who has been recognized, certified by the state, tribe, territory, or agency responsible for regulating pesticides as being competent to use or supervise the use of RUPs. There are two types of certified pesticide applicators, private and commercial. Private applicators are defined as certified applicators who use or supervise the use of any RUP for the purpose of producing an agricultural commodity, e.g. field and forage crops, fruit, vegetables, nursery stock, Christmas trees, greenhouse plants, and livestock on their own property or property they rent or lease. Commercial applicators are individuals who use or supervise the use of any RUP for any purpose on any property except for those listed under the definition of a private applicator. So I think we can get a quick understanding on this. When we're talking about a private applicator, again, this would be somebody like you're seeing here that owns a farm or something like that that's tending their own crops, or a greenhouse as we're showing in the current image. These would be two of those private type of applicators Whereas when you have somebody working for a pest control company that's signing people under contracts and going to their homes or businesses and doing general pest control, that would be a commercial applicator. That would be somebody going in and performing a pest control service and charging them for that service. So that would be the difference in private and commercial applicators. Only certified applicators or individuals under their direct supervision may mix, load, or apply RUPs. To become certified, a person must demonstrate knowledge of and competency in pesticide use and handling. Certified applicators must know how to read pesticide labeling and be able to follow directions to use these products properly and safely. Pesticide applicator certification programs and the RUP classification process provide an alternative to cancellation of these important and beneficial pesticides or more stringent controls on their use. Two quick things on this slide that we need to understand. Certified applicators are somebody under their direct supervision. So in some states, you may not have to be a certified applicator if you're under the direct supervision of one that's watching you do the treatment, or at least is on site for that matter. When we talk about knowledge and competency, this again would be passing some sort of a certification program or showing that you've had specific training in a state. Some states don't require you to take an exam, but they will require things like 24 or 40 hours of documented pesticide use and handling training. Obviously, we've talked again, certified applicators must know how to read pesticide labeling and be able to follow directions to use these products properly and safely. You have to be able to read pesticide labeling. The label is the law. You have to follow the directions, and you have to understand how to use those products properly and safely. Not just for yourself, because obviously it's very important for you, but also for your clients and the environment around you. Pesticide registration. Except for minimum risk pesticides, all pesticides distributed and sold in the United States must be registered by the EPA. Pesticide registration is based on scientific data showing that these products will not cause unreasonable risk to human health, workers, or the environment when used as directed on the labeling. Make sure you understand this. Make sure you understand this. This is another common exam question. All pesticides except the minimum risk ones distributed and sold in the United States must be registered by whom? The EPA. The other thing to understand here is when you use these products according to the label, they do not cause unreasonable risk to human health, workers, or the environment. If you don't use them according to the label, you're putting yourself and everybody at risk. The EPA has tested these products, they've approved them, but you have to follow the label to make sure that you keep yourself and the environment around you healthy and safe. The process of registering a pesticide begins with the pesticide company, manufacturer, or registrant's submission of an application package to EPA. EPA's review of this application includes an assessment of the risks to human health and the environment that may be posed by the use of the pesticide. Based on this review, EPA may classify the pesticide as restricted use or general use, or the pesticide may remain unclassified. Depending on the class of pesticide and the priority assigned to it, this review and decision process may take several years. Pesticides must be registered or exempted from registration by EPA's Office of Pesticide Programs before they may be sold or distributed in the United States. Once registered, a pesticide may not legally be used unless the use is consistent with the approved directions for use on the pesticide's labeling. One thing I would just say here is the fact that when people do get a product approved, it can take years, it can take millions of dollars, a lot of research to get the product where it needs to be. So once a product gets this EPA registration, you need to understand It is a solid product, it's been tested, and it's ready to go, and it can be used safely. FIFRA has several types of registration and exemption actions that enable pesticides to be used in the United States. Federal registration of pesticides under Section 3, special local need registrations under Section 24C, emergency exemptions under Section 18, exemption of minimum risk pesticides from registration under Section 25B. Of the utmost importance here is going to be the 25B section. There's going to be 6 conditions required for a product to meet the 25B requirements. 25B pesticide product labeling expectations. 1. Products must comply with the 6 conditions outlined by EPA. A. Condition 1, active ingredients. The product's active ingredients must only be those listed in 40 CFR 152.25 F1. B. Condition 2, inert ingredients. The product's inert ingredients must only be those listed in 40 CFR 152.25 F2 and 40 CFR 180.950 A, B, C, and E. C. Condition 3, ingredients listed on the label. All ingredients in a 25B product must be listed by label display name on the label. D. Condition 4, health-related claims. The label cannot state or imply that the product can or will control or reduce organisms that pose a threat to human health or insects or rodents carrying specific diseases. E. Condition 5, company name and contact information. The name of the producer or company for whom the product was produced and the company's contact information, which includes a street address or P.O. box, must be displayed prominently on the product label. F. Condition 6, label statements. The label cannot include any false or misleading statements as described in 40 CFR 156.10 A 5 I through V III. One final note on Section 25B. We need to just mention that this can be described as a provision in FIFRA that exempts certain pesticides from registration with the EPA. Those of you taking exams, again, you're going to see questions on this quite often. Understand this is just a provision in FIFRA that exempts certain pesticides from registration with the EPA. EPA also plays a role in regulating devices used to control pests. A device is any instrument or contrivance other than a firearm intended to trap, destroy, repel, or mitigate any pest. A black light trap is an example of a device. Unlike pesticides, devices do not need to be registered. However, EPA does require the establishment producing the device to be registered. Devices are subject to certain labeling, packaging, record keeping, and import-export requirements. Tolerances. Pesticides are widely used in producing food. These pesticides may remain in small amounts called residues in or on fruits, vegetables, grains, and animal feed. Before allowing the use of a pesticide on food crops, EPA sets a tolerance or maximum residue limit. A tolerance is the amount of pesticide residue that may legally remain on or in treated crops and animals and animal products such as milk or eggs to be sold for food or feed. Federal agencies monitor food and feed products for tolerance violations, such as when the residue exceeds the established tolerance. If residues are found to exceed the tolerance, the commodity will be condemned or subject to seizure by the government, and violators may be prosecuted. Just to quickly note, these tolerances basically are protecting our food supply from having an overabundance of pesticides. So many of you may understand when you buy foods in the store, they're going to have a level of pesticides in them, but this tolerance is going to help manage what that level is. So in theory, the government's doing a pretty good job of managing how much pesticides is used in and on our food to help protect us. In setting the tolerance, EPA must make a safety finding that the pesticide can be used with reasonable certainty of no harm. To make this finding, EPA considers the toxicity of the pesticide and its breakdown products, how much of the pesticide is applied and how often, how much of the pesticide, i.e. the residue, remains in or on food by the time it is marketed and prepared. Pesticide manufacturers must submit a wide variety of scientific studies for review before EPA sets a tolerance. These data are designed to identify possible harmful effects the chemical could have on humans, its toxicity, the amount of the chemical residue or breakdown products likely to remain in or on food, and other possible sources of exposure to the pesticide, e.g. through use in homes or other places. Science is the backbone of the EPA's decision-making. The agency's ability to pursue its mission to protect human health and the environment depends upon the integrity and quality of the science on which it relies. The environmental policies, decisions, guidance, and regulations that impact the lives of all Americans must be grounded, at a most fundamental level, in sound, high-quality science. The EPA regulates pesticides to ensure that they do not pose unreasonable risks to human health or the environment. As part of that effort, the EPA requires extensive test data from pesticide producers that demonstrate pesticide products can be used without causing harm to human health and the environment. The EPA evaluates information from all kinds of sources: pesticide companies, other governments, academia, and the published scientific literature. EPA scientists and analysts carefully review these data to determine whether to register or license a pesticide product or use, and whether specific restrictions are necessary. EPA maintains a transparent, public process for assessing potential risk to human health when evaluating pesticide products. A pesticide applicator cannot measure residues on crops or in livestock commodities because such measurements require highly specialized equipment and techniques. But by following labeling instructions, you can be sure that products you have treated with pesticides have residues well below the tolerance level when put on the market. It is especially important to follow instructions on the correct application rate and the minimum number of days allowed between pesticide application and harvest, slaughter, freshening, or grazing. EPA is responsible for ensuring that each registered pesticide continues to meet safety standards to protect human health and the environment. These standards have become stricter over the years as EPA's ability to evaluate the potential harmful effects of pesticides has improved. Therefore, the agency has embarked on several programs to reevaluate pesticides as the standards evolve. Re-registration and tolerance reassessment. EPA has completed a one-time program to review older pesticides, those initially registered before November 1984, to ensure that they meet current scientific and regulatory standards. This process, called re-registration, considered the human health, environmental, and ecological effects of pesticides. It resulted in numerous actions to reduce risk of concern identified during the review. The conclusions of those reviews are called re-registration eligibility decisions, REDs. In addition to the re-registration effort, Congress passed the 1996 Food Quality Protection Act, FQPA, amendments to FIFRA. It also passed the Federal Food, Drug, and Cosmetics Act, FFDCA, which called for reassessing existing tolerances and tolerance exemptions to ensure that they meet the legal safety standard. Implementation of REDs and tolerance reassessment decisions, including the movement of revised labeling into the marketplace, has continued beyond the completion of the reviews in 2008. Finally, FQPA mandated a new program, Registration Review, under safely as policies and practices change. As the ability to assess risk evolves, Registration Review allows EPA to verify that all registered pesticides continue to meet the statutory standard of no unreasonable adverse effects. Through these assessments, EPA has identified risk of concern for some uses. In many cases, these risks could be reduced to acceptable levels by changing the product labeling. Examples include use sites, application rates and methods, timing of harvest, restricted entry intervals, and requirements for personal protective equipment (PPE). Changes in application rates, timing of application to crop harvest, or the removal of some uses can reduce crop residues, decreasing dietary exposure and risk. Labeling requirements for PPE, closed systems, and extended restricted entry intervals may be established to protect agricultural workers and handlers. Limitations on applications in some soil types reduce the chance of groundwater contamination. EPA expects the implementation of revised labeling in the field to be a continuing process. There's some great points we need to talk about here. When it comes to labeling, the EPA is constantly reevaluating these labels because they're looking at different changes in application rates, timing of applications, and even looking at some uses that may be removed from labels, or there may be some uses added. You have to continue to read labels. Labels are changing, and those of you that don't think it's important to read the label because you already know it, maybe this will help you understand. The labels can change at any time, and when these labels are updated, if you're going by your head knowledge or an old label, you may be misapplying the product. How do these processes affect you, the applicator? You must review each product's labeling before application to check for recent changes and to ensure that you use the product according to the directions. Product labeling can change frequently. You can avoid misuse by making sure you are referencing the most current product labeling. Violations and federal penalties. A variety of actions by pesticide manufacturers, sellers, distributors, and users are considered unlawful acts under the provisions of FIFRA. These acts include distributing, selling, or delivering an unregistered pesticide, making any advertising claim about a pesticide not included in the registration statement, selling any registered pesticide if its content does not conform to labeling data, selling an adulterated or misbranded pesticide, detaching, altering, defacing, or destroying any part of a container or labeling. Most of you on this course are going to be people that are out using the pesticide. So when we talk about what's considered an unlawful act, I'm really thinking about users here. You cannot do any of the things talked about here. You can't make an advertising claim about a pesticide not included in the registration statement. Those of you making marketing pieces really need to think about, before I put advertising out there about a product, let me make sure it's on the label and it's exactly what the product can do. Do not put false statements out there because that is illegal. Also on here that I think is important, detaching, altering, defacing, or destroying any part of a container or labeling. Don't destroy the containers. Don't move pesticides from one container to another. Pesticides are meant to be stored in their original containers with the original labeling. Nothing can get you in trouble quicker than trying to move pesticides out of their original container and putting different labels on them. You're just going to end up with a big problem, and it's not something you want to do. Violations and federal penalties. A variety of actions by pesticide manufacturers, sellers, distributors, and users are considered unlawful acts under the provisions of FIFRA. These acts include refusing to keep records or permit authorized EPA inspections, making a guarantee other than that specified by the labeling, advertising an RUP without giving the product classification, making an RUP available to a non-certified applicator, except as provided by law, using a pesticide in any manner inconsistent with its labeling. Here's even further details for us on violations and federal penalties. Make sure to keep records of all pesticides used. Now, each state's got guidelines on this. Some states are only 2 years, some states are 5 years. In my mind, I don't know why you wouldn't keep them longer. I like that 5-year period, especially nowadays since most records are digital anyways. It's just better to protect yourself, your employees, and your clients. You also have to permit authorized EPA inspections, so it's not like the EPA is typically going to show up at your door, but if they do have the right to inspect your facility, and you have to allow them access. Now, we talked about making guarantees other than what's on the label, and we know we can't do that. You also cannot advertise an RUP without giving the product classification. So make sure you include the classification of the product itself before you do any marketing. And then obviously you would never want to make an RUP available to a non-certified applicator unless it's provided by law. What that basically means is don't give your customers product. I know a lot of times you're out in the field, customers like, hey, can you leave a can of this or that at my home? That way I don't have to call you back out. Tell them, no, unfortunately that's a violation of federal law. I can't give you this product because it is a restricted use pesticide, and I would be under penalty of federal law if I did this. Penalties. Anyone who uses a pesticide in a manner inconsistent with its labeling, directions, and restrictions may be subject to civil and/or criminal penalties. Generally, any registrant, commercial applicator, wholesaler, dealer, retailer, or other distributor in violation of FIFRA may be assessed a civil penalty. In determining civil penalties, EPA considers the size of the business, how the penalty may affect the ability of the firm to remain in business, and the gravity of the violation. Other considerations include any economic benefit realized by illegal profits or unfair gains. In cases involving only minor violations, EPA may issue a warning instead of assessing a penalty. A knowing, intentional violation by any registrant, applicant for registration, producer, commercial applicator of restricted use pesticide, or other person distributing or selling pesticides or devices is a criminal act. The penalty may include a fine and/or up to 1 year imprisonment. A knowing violation by a private applicator is a misdemeanor and will result in a fine and/or up to 30 days imprisonment. Remember, you must use all pesticides exactly according to labeling directions. The label is the law. The thing we're introducing here that's very important for you to know, and I'm not trying to scare people, but if you use a product knowingly against its label, which if you think about it, if you read the label, you would know obviously if you're doing that. But if you don't read the label, it could be considered you knowingly use the product wrong. And when it comes down to civil fines and/or criminal penalties, as we've introduced here, I don't want to be explaining that. The reality is read the label, know the label, follow the label at all times. Federal pesticide regulations under FIFRA. EPA develops regulations to carry out the provisions of FIFRA. The primary federal regulations pertaining to pesticides are found in Parts 150 to 189 of Title 40 of the Code of Federal Regulations. The most important federal pesticide regulations of concern to pesticide applicators are briefly summarized below. Pesticide Container and Containment Regulation 40 CFR Part 165. In 2006, EPA published regulations on pesticide containers and containment structures to ensure the safe use, refill, and disposal of containers. While most of these requirements apply to pesticide manufacturers and refillers, Commercial applicators who store pesticides in containers greater than 500 gallons may need to verify that the container is surrounded by a secondary containment structure. I would say very few of you would fall underneath this concern. I would mention this though, those of you doing major lawn applications and farm applications, just keep in mind if you do have containers greater than 500 gallons, you're going to need that secondary container underneath. So just make sure you've got a secondary container in place, a structure. If there's leakage or something like that, then it would be collected in that container. This is something you can find out from your pesticide manufacturers and suppliers if you have questions in that area. Contact your state pesticide regulatory agency because some states are implementing state, instead of federal, containment regulations. In addition, all applicators must follow the container handling and cleaning instructions in the storage and disposal section of the pesticide labeling. Now we can take this right back to reading the label. As mentioned, you need to read the label before you use any product. But also with storage and disposal, the label is going to have some very specific things. Now you may see different things about storing in dry areas or storing above a certain temperature or below a certain temperature. That's important. Those of you that have products in the back of your trucks when it's 115 degrees in Phoenix, Arizona, how well do you think that product's going to perform when you put it in a sprayer? Probably not very well, right? So we really need to think about what these storage and disposal labels say, and we need to figure out how to store the products correctly, as well as disposal. A lot of times you're going to see triple rinse and puncture for a lot of pesticide containers, but that's not always true either. So keep in mind you have to read the label because at some point you're going to be disposing of that pesticide container, and if you don't know how to dispose of it, you're probably just going to look at it, see it's empty, throw it in the trash can, and move on. Unfortunately, again, that would be a violation of federal law, and those are the things that can get us in trouble in the long run. Worker Protection Standard Regulation 40, CFR Part 170. EPA's Worker Protection Standard, WPS, is intended to reduce the incidence of occupational pesticide exposure and related illnesses and injuries among agricultural workers and pesticide handlers covered by the rule. The WPS requires employers to provide agricultural workers and pesticide handlers with certain protections. These include pesticide safety training, personal protective equipment, and decontamination supplies designed to prevent or reduce harm from occupational pesticide exposures. Further, with Worker Protection Standard Regulation 40 CFR Part 170, owners and operators of agricultural establishments, such as farms, nurseries, and forest and greenhouse operations producing agricultural plants, and of commercial businesses hired to apply pesticides or to perform crop advising tasks on agricultural establishments must comply with the WPS. The WPS also requires employers to maintain certain records and to display specific pesticide safety information on the premises. When we talk about these worker protection standards, I think a lot of you are probably surprised. A lot of you as employers haven't even thought about this. The fact that you do need to have WPS procedures in place, you need to have training. It's something we don't typically think about. I know I've owned a lot of pest control companies through the years, and I've had to set these types of things up, and especially after I learned the law, I definitely didn't want to be in violation of it. So keep in mind, it doesn't matter if you're a private applicator or a commercial applicator, you're going to need this type of training in place. And it's going to be a really good thing. It's going to help protect your workers. It's going to help protect you as a company. It's also going to help protect the people we're spraying around, whether it's residential, commercial. It's just going to help us protect people all the way around. It's something we have to do legally for our companies anyways, and it's just a good business practice overall. Certification of Pesticide Applicators Regulation 40 CFR Part 171. As previously mentioned, EPA has the authority to classify certain products as RUPs and to require anyone applying or supervising the use of RUPs to become a certified pesticide applicator. To carry out this requirement, EPA has established standards for the certification of pesticide applicators and requirements for state, tribal, territorial, and federal agencies to establish pesticide applicator certification programs. Any such agency that wants to certify applicators to use RUPs must have an EPA-approved certification plan that describes how the certifying authority will carry out its credentialing program. This includes the requirements to become a certified applicator, recertification requirements, and the standards of competency for each category of applicator. At a minimum, all certification plans must meet federal standards and requirements. Most of you are going to be certified under state governing bodies, but one thing you need to make sure is who the governing body is, because there are times when you'll be certified under a tribal authority or even the federal government. It doesn't really matter so much who you're supposed to be certified under, it just matters that you figure out who it is and you get your certification. The other thing you're going to have a good understanding of is recertification. What are the recertification requirements of the governing body of my license? If you don't understand this, if you miss out on this and you don't understand, if you don't understand this, you're going to have some major problems. You may be out applying without a certification, or you could even lose your license and have to take another exam. And I'm going to say that most of you don't want to have to take exams twice, so make sure you keep up with your recertification, check with your governing body, and make sure you meet all requirements long before your license is due. All 50 states, as well as several tribes, territories, and federal agencies, have EPA-approved certification plans and pesticide applicator certification programs. Additionally, all 50 states have signed cooperative enforcement agreements with EPA that designate an agency within the state, i.e. the state lead agency, as the primary pesticide regulatory authority to enforce the provisions of FIFRA. In some situations, more than one state agency may be designated to enforce various parts of FIFRA. For example, some states have structural pest control boards responsible for regulating the structural pest control industry. Other federal laws. Although FIFRA is the main federal law regulating pesticide use, the FFDCA is another statute that provides the EPA with regulatory authority for pesticides. Other federal laws cover certain pesticide-related activities, such as transportation, storage, disposal, protecting the safety of employees, and reporting accidents and spills. Applicators will encounter other laws and regulations that they must be aware of and obey. In some cases, the pesticide labeling will alert the applicator to these laws. Federal Food, Drug, and Cosmetic Act. The FFDCA governs the establishment of pesticide tolerances for food and feed products. As discussed earlier, a tolerance is the maximum level of pesticide residues allowed in or on human food and animal feed. The EPA and the Food and Drug Administration are responsible for administering this act. I can't tell you how many times I've seen this on exams, but just make sure you understand and remember the FFDCA governs the establishment of pesticide tolerances for food and feed products. Food Quality Protection Act. The FQPA set a higher standard for pesticides used on food. It established a single, health-based standard to be used when assessing the risk of pesticide residues in food or feed. The safety standard considers the aggregate risk from dietary and other non-occupational sources of exposure, such as drinking water and residential lawn use. In addition, when setting new or reassessing existing tolerances, the FQPA requires EPA to focus explicitly on exposures and risks to infants and children. This act also requires EPA to assume an additional safety factor to account for any uncertainty in data. Other FQPA mandates require EPA to establish a tolerance only if there's a reasonable certainty that no harm will result from all combined sources of exposure to pesticides, aggregate exposures. The combined effects of human exposure to different pesticides that may act in similar ways on the body, cumulative exposure, must also be considered. Review all old pesticides to make sure that the residues allowed on food meet the new safety standard. Test pesticides for endocrine disruption potential. Endocrine disruptors may be linked to a variety of sexual, developmental, behavioral, and reproductive problems. Distribute a brochure discussing pesticides on foods to supermarkets to better inform the public. Endangered Species Act. The Endangered Species Act, ESA, is a federal law administered by the U.S. Fish and Wildlife Service and the National Marine Fisheries Service, jointly referred to as the services. The ESA makes it illegal to kill, harm, or collect endangered or threatened wildlife or fish, or to remove endangered or threatened plants from areas under federal jurisdiction. It also requires other federal agencies to ensure that any action they carry out or authorize is not likely to jeopardize the continued existence of any endangered or threatened species or to destroy or harm its critical habitat. Therefore, EPA must ensure that no registered pesticide use is likely to jeopardize the survival of any endangered or threatened species. If we sit and think about it, endangered species are a really big deal. There are over 1,300 species listed as either endangered or threatened in the United States under the Endangered Species Act. The Fish and Wildlife Service, in the Department of the Interior, and NOAA's National Marine Fisheries Service, in the Department of Commerce, share responsibility for administering the ESA. Their responsibilities include listing and delisting species, designing critical habitat, developing recovery plans, and evaluating the status of the species every 5 years in 5-year reviews. Endangered Species Act ESA. Each state pesticide regulatory agency is responsible for implementing the federal Endangered Species Protection Program in cooperation with EPA. Under this program, a pesticide product that might harm an endangered species carries a labeling statement instructing applicators to consult a county bulletin to determine if they must take any special precautions when using the product in a specific county. EPA is developing these county bulletins and making them available through the internet-based Bulletins Live system. Precautionary measures included in the bulletins may include buffer strips, reduced application rates, or timing restrictions. An applicator might also be prohibited from using the pesticide within the identified habitat. Application records. The United States Department of Agriculture, USDA, administers the program that establishes federal record-keeping requirements for private applicators. States establish pesticide record-keeping requirements for commercial applicators. States may also establish private applicator record-keeping requirements that exceed USDA's. Both private and commercial applicators must be aware of the record-keeping requirements for their industry. Let's stop here for a key point. We need to remember that the USDA administers the program that establishes federal record-keeping requirements for private applicators. We'll also need to understand that states establish record-keeping requirements for commercial applicators. At the same point in time, a lot of states also do handle the record-keeping requirements for private applicators. More often than not, with the departments of agriculture that we work with, we see that being a pretty common theme. But it's up to you to figure out who administers your program, who's in charge of it, and what the requirements are, because every state is going to be a little bit different. Like I mentioned before, some states can be 2 years, some states 5 years, some states 3 years. They're going to be different, and you just have to figure out what your state guidelines are. Keeping appropriate application records not only meets the legal requirements, but is also a wise practice because records are invaluable documentation in the event of a complaint or lawsuit, help determine which pesticide treatments work, which did not work, and why, help applicators plan future purchases so that they buy only the amount needed, provide information needed by medical staff, document the steps taken to protect farm workers and the environment, are used for federal and state surveys. Training records. Owners and operators of pesticide application businesses should consider keeping documentation of employee training and pesticide use and handling. Though not currently required by federal law, such documentation may be required in the future. Therefore, make sure you are aware of applicable training requirements. Your state, tribal, territorial, or federal pesticide regulatory agency may require written proof that employees received training on proper pesticide use when they were hired. In the case of the WPS, records document that the mandatory training requirements were satisfied. And I just want to mention this real quick on this slide. Most states are going to require some sort of training, some sort of written proof that that training has been received. Make sure you check with your states because, as we mentioned here, there is no federal requirement, but almost all states are going to require some written proof. I currently live in Florida, and every time a company hires an employee, they have to have 40 hours of documented training before they can get the initial ID card to do pesticide applications. Consider including the following in your training records: employee's name and social security or work identification number, date of the training, materials used and source provider of the training, employee's signature and the date signed. So keep in mind, this would be what I would call verified training. I don't know about keeping people's social security numbers these days. Just be very careful on how you store those. But in reality, make sure you have the name, you have some sort of identification number, the date of the training, and what the training was and who provided it. Now you can use companies like I work for, American Pest CEUs. Some of you even do some of your training in-house. Either way, if you document and the employee signs and dates it, it's proof that you provided the training, and this can really keep you out of major problems in the long run. Summary. Federal pesticide laws and regulations are designed to protect the public and the environment from possible adverse effects of pesticides. It is your responsibility as an applicator to comply with these laws and regulations. FIFRA is the primary law that regulates how pesticides are produced, transported, sold, used, and disposed of. FIFRA also establishes the process for the registration and re-registration of pesticide products and for the certification of pesticide applicators. All states, tribes, and territories must comply with FIFRA and its accompanying regulations. They must establish additional pesticide regulations more but not less restrictive than FIFRA. The FFDCA regulates the tolerances, i.e. the maximum amount of pesticide residue that may remain in human food and animal feed. To set tolerance levels, EPA requires the review of many scientific studies to ensure the safety of food and feed products in the United States. The FQPA has put in place even more stringent requirements to assess the risk of pesticide residues in food or feed. Under this standard, EPA must now consider the risk of aggregate, combined pesticide exposures. These include exposure through diet, residential lawn and home uses of pesticides, and residues that may be found in drinking water. The standard also emphasizes the risk of pesticide exposure to infants and children. Under the FQPA, EPA must review all old and new pesticides to make sure the residues allowed on food and feed meet the new safety standard. The ESA protects endangered or threatened species from harm, including pesticide injury. Pesticide products that might harm an endangered species must carry a statement instructing applicators to consult a county bulletin to determine if they must take any special measures to protect an endangered species when using this product. All applicators must comply with record-keeping requirements for RUP applications. Even though it is not a current federal requirement, maintaining employee training records is a good idea. Such records, which may eventually be required by the applicator's state, tribal, territorial, or federal agency, document that the WPS safety training requirement has been met. Congratulations, you have completed the course. Please proceed to the quiz to receive your credit.